Sorry, Judge, thank you.
It won't, okay. Oh,
There it is.
it's written one? She's in custody, but
Yeah, no, just, no, the reason I didn't see it at first is, do they spell her name differently than on the Son of War?
Armoni. Okay. Sorry, I was just Williams.
Yeah, yeah.
Is that good? Okay. I don't either, but you never know. Good morning, Your Honor.
Good afternoon.
Or good, I'm sorry, good afternoon. It's been a long day, if you can't tell. So we do have Verna. I checked them. We have Verna, Crystal, and Todrick, right?
All right, so do we want to do these things first, or do we want to do this thing first?
Your Honor, I obviously would prefer to do the co-defendants that are on the docket, and today that's Verna Isaacs, Crystal Isaacs, and Troderick Holland. And they're all part of the same case. Judge Siegel issued
Right,
an arrest warrant.
I've got those in the stack here. They're not necessarily in that order.
Okay, whatever order Your Honor prefers.
Well, let me just go through the PCs that I've got here then.
There you are, sir. I can hear help too.
All right, Jacobs.
Judge, we didn't hear what you said.
Jacobs?
Can you put the microphone closer? Thank you.
Is that better? Jacobs?
Yes. Judge, no, I've been informed he bonded.
No, it's a female.
Yeah, I've been informed she bonded. I'm sorry.
Okay. All right, so I've got Isaacs.
That person's
Verna.
24 hour, Judge.
All right, Verna Isaacs.
Judge, we have, her son is here, as well as a person from the bond agency.
Okay,
Hello, Your Honor.
good morning.
Morning.
Afternoon.
I just wanted to tell you, start off by saying, if I could, my mom has been a loyal member of the community for 30-plus years. She's been in the community 30-plus years. She's never, ever had an arrest on her name. She's never had any trouble. You know, we've been a clean-cut family. My whole knowledge about all of this, I don't know anything that's going on. I know this is a huge mistake.
Andre, don't talk about the facts of the case at this
Right.
point.
I
Just your
do know
mom's
that
ties to the
this is-
community.
Yeah, this is a huge mistake on my mother.
Don't say anything about the facts of the case, whether she made a mistake, didn't make a mistake.
Right.
She's never been arrested before.
She's never been arrested before, and she's never had anything on her. She's been same place, same address, living in Broward County. She's always been, 30-plus years.
Now, Andre, when you and I spoke earlier, you indicated that you might be able to come up with maybe $1,000 or so to get your mom out.
Yes, sir.
And you have someone from the bond agency present here in the court as well?
Yes, sir. Yes, I do. Yes, Your Honor. I have someone here present, and I work 2 jobs. I'm trying to just, pay my way just to pay the bills, just to get by. I don't have the kind of money that bond is set. I'm asking if you could do something to help me.
I'm sure the state can enlighten us to some degree, Judge, but my understanding is that Verna Isaac's involvement in the case might be minimal compared to other co-defendants who have been, well, we had some of them in court this morning, and we have 2 more after this case. I think her involvement was minimal. She does have family support, as you can tell. She has been living here in the community for almost 40 years. She is not currently working, but she does receive disability. She has, I think, a couple of cars that she can put up as collateral for bond. And she has no prior criminal history whatsoever. She is 63 years old and has never been arrested in her life. I'd ask the court to consider reducing her bond to $10,000 total, which I believe, and the bondsman has indicated to me that's something that they would be able to afford.
What says the state?
And good afternoon again, Your Honor. Whitney Mackey on behalf of the state. Your Honor, I would ask that the $80,000 total bond that's currently in place remain in place. As you're aware, Judge Siegel did go over each and every affidavit, including that of Verna Isaacs, over this past weekend and carefully crafted a bond based upon the charges and the involvement of this particular defendant in this entire scheme. Your Honor, Miss Isaacs, Verna Isaacs, bribed and personally met with a uniformed deputy and gave him a package full of money, a folded magazine full of money, so that the scheme that Deontay Rosales was currently engaged in could continue. Your Honor, I also want to point out that Verna Isaacs, when her daughter, Crystal Isaacs, who's also a co-defendant in this case, started to waver and back down and be hesitant about becoming involved in this bribery, she basically, and I don't want to quote exactly what she said because it's vulgar, but called her a wimp and said, if you don't do it, I'll just go do it. And that's when she met with the fully uniformed deputy in the Broward Mall parking lot and did, in fact, commit a bribery of that uniformed deputy and allowed for Deontay Rosales to obtain a contraband cell phone while in custody. So, Your Honor, based on that and the nature of these charges and the overall scheme of this racketeering, I would ask that bond stay in place of $80,000.
Okay, anything further?
Judge, her guilt or innocence will be decided at a later date. The issue before the court is, based on this nonviolent offense, based on the fact that she is 63 years old and has never been arrested in her life, that fact that she has a strong ties to the community, as evidenced by her son being here, as evidenced by the bondsperson being here, she's not, it would seem to me, a flight risk. And that, I think, should be the court's main concern, is what is the likelihood of future harm to the community. She does not pose a danger to the community. Her risk of flight. She is a member of this community. She is a citizen here. She does not pose a flight risk. So I would ask the court to consider setting the bond into something that the family has indicated they could make to bond her out, which would be a $10,000 bond.
All right, thank you. What the court will do is on count one, I will reduce it to 35,000, count two, 15,000, count three, 5,000, all come with the level one with GPS, no weapons, no passport.
Thank you so much, Your Honor.
Yes, sir.
Thank you, Your Honor.
I'm gonna do my best, sir.
Next, we have Crystal Isaacs.
She's in Paul Ryan, Judge. I did not get a chance to speak with Miss Isaacs.
All right, well, this is on a warrant. The count one is set at 200,000, count two, 50,000, count three, 50,000, count four, 10,000, count five, no bond, count six, 10,000, seven, 10,000, count eight, 100,000, count nine, 3,000, count 10, 20,000, all with level one with GPS, no weapons.
In regard to count five, Your Honor, I'd ask
passport.
you to set a bond for Crystal Isaacs. Holding her no bond at this point is the most severe form of pretrial detention. This court would have to make a finding that the proof is evident and the presumption of guilt is great.
I will make a proof evident presumption great preliminary finding at this point.
Thank you, Your Honor.
That is over defense objection, Your Honor.
Yes, sir.
Don't discuss your case with anyone, Crystal. Okay, you hear me? Okay.
Bahai Danji.
No fraud, Your Honor.
All right,
Your Honor, I got stopped with a knife. That knife was used.
Don't discuss the facts of your case.
Mr. Reedy's going to tell you not to discuss the facts of your case at this point.
And I'll tell you again, don't discuss the facts of your case.
So that's probably good advice. All right, bond on count one is 100. Count two, there is It's an ROR, and on count 3, there is a capious with a $5,000 bond due find probable cause. Stephen Stearns.
Mr. Stearns is here, present judge at Maine. He declined to serve as public defender.
All right, sir, there's a violation of probation warrant for 500.
Yes.
All right. You'll appear in front of Division MQ Judge. Judge Gottlieb.
Can I bond out, sir?
Yeah, 500. Okay.
Mr. Stearns, could you come back up?
Yep.
I've been advised that there may be more charges coming from Palm Beach County. I don't
Just
know what they
FYI.
are, but that's just what I've been told.
Leonard Hendricks.
Mr. Hendricks is approaching.
All right. Court finds probable cause. Set bond 10,000.
Judge, respectfully, and it may be academic, but Mr. Hendricks is currently serving a prison sentence. He's been in custody for 18 months. Financially has no money in bank, no property. He has no sort of financial resources, so $10,000 would be something unattainable for Mr. Hendricks.
Well, he's serving a state prison sentence?
Correct.
All right. Well, I think 10,000 is fine.
Well, actually, he was brought in on a court order, and he should have been heard in front of his division judge on
Hold on, Mr. Hendricks.
4810 this morning. For some reason, he did not appear on the docket. He appeared on the magistrate docket. So technically, he should be held no bond.
Well, I'll give him that 10,000 on this, and then if he posts that, he can go back to Florida State Prison. Tavon Watts.
Mr. Watts, come on up, please.
And, Your Honor, Mr. Watts, Eric Linder on behalf of the state.
Hold on, let him get up here.
Sure.
Yes, sir.
I know on some of the charges, there's arrest warrants. I don't believe the court had a copy of the affidavit. I printed out a copy if you'd like to see. It's on the grand theft counts 4, 5, and 6.
Yes.
Okay.
Actually, no, I've got, all right, so Mr. Watts, on 1, 2, and 3, those are no bond capiouses, and they're not for the magistrate. On 4, 5, and 6, I've reviewed the affidavits that were submitted to Judge Holmes and concur with her finding. And bond is set on 4 at 5,000, 5 at 7,500, 6 at 7,500, all with a Nebula requirement.
Judge, if the defense could be heard, in speaking with Mr. Watts, he's been residing in South Florida his whole entire life. He's currently employed. He just started working at Costco. He started working there for 2 weeks now. He's getting paid $17 an hour. He's hoping once he can hopefully appear before Judge Bailey and potentially get a bond on counts 1, 2, and 3, he wants to potentially post bond on 4, 5, and 6. The only person that's going to be able to post his bond is his mother that works for a call center making minimum wage. So $20,000 on counts 4, 5, and 6. we'd be asking you to reduce it and considering you to $2,500 on each count without the nebula requirement.
Thank you. Court's comfortable with the amount that was set and thinks that is the minimum necessary to ensure his presence and protect the community. He's also has to answer to those no bonds, so guess he could bring it up with the division judge.
No, I gotta mention all his cases.
Christopher Nelson.
Commissioner Nelson declines to serve as public defender, Judge.
All righty. State on this one, I did not have, I just have the booking sheet, no.
So do I, Judge. I don't know what happened. I wasn't provided with the probable cause either.
Well,
Sheila, do you have anything?
then I'm
on
not gonna find probable cause. I'll give you 48 hours to perfect.
Christopher Nelson.
It's on Nelson. That's just on counts 1 and 2. There is 3 and 4, which are VOPs, and those are no bond. Oh, you got a PC? Wonderful. Let me take a look.
You got a PC?
I'm looking at one right now.
We can hear you. You may want to shut that mic off. Or not say anything.
All right. All right, having had a chance to now review the probable cause affidavit, I do find probable cause. Count 1, bond will be set at $7,500. Count 2, bond will be set at $1,000. And it's no bond 3 and 4 on the VOP warrants. Kelvin Nelson.
Commissioner Nelson is approaching, Judge. He declined to serve as public defender.
All righty. These are violation of probation warrants, no bond, and it appears that he's set 719 in front of the division judge. Oh, you want that back? I stuck it with the paperwork over here, so. We'll get it back to you. Darius Chappelle?
Mr. Chappelle is here at Maine. He's approaching. He declined to serve as public defender.
All right, on count 1, probable cause, bond set at $100. Count 2 is ROR. Being held no bond on 3, 4, and 5 for violations of community control warrant. There's a $500 capias on 6 in a misdemeanor case, and no bond on 7 and 8 for violation of pretrial warrants. He'll appear on 718 in front of the felony division judge and 717 in front of the misdemeanor division judge.
There are 3 more counts, Judge.
Torrance Howard.
Mr. Howard's approaching.
Find probable cause on it, setting bond at $2,500.
Judge, Mr. Howard's advising me, unfortunately, he is homeless, financially can't afford to post that monetary bond. Would you consider leaving it at the standard bond of $750?
given his prior history, we think that's the minimum amount that will ensure his presence and protect the community.
Yes, Judge.
Brian Fela?
Mr. Failer is approaching.
All right, bond is set in count 3 at 1,000. Everything else ROR. Find probable cause.
Judge, respectfully and speaking, Mr. Failure, he's requesting Your Honor consider an ROR. He's adamant as far as not being guilty. I did explain to him he'll have his opportunity in court to contest this. He's been residing in our community his whole life. He's 35 years old. He's an insurance agent, just got employed last week. He didn't receive even his first paycheck, but he anticipates it's going to be $800. Judge, he lives in Fort Lauderdale. He's living with his mother. Financially, he doesn't think that his mother can help with the bond at this point. So what we'd be requesting is for you to consider an ROR on count 3.
State?
Your Honor, Mr. Faela's criminal history includes 2005 possession of methamphetamine, possession of marijuana, 2004 DUI property damage, and 04 DWS.
So he's basically not been arrested in 11 years?
12 years.
Okay, 12.
Is there someone
Well,
from pretrial
well-
here?
We were unable to complete the interview with him, Your Honor. He was adamant that he was set up. He wouldn't talk to us because he just wants to get out. He was set up and wouldn't give us any information.
And
Pretrial release is saying that Mr. Failure was adamant about his innocence and did not want to speak to pretrial release, which he
Honor.
might be reconsidering that decision at this time.
Your Honor, he also, there was an, there was an arrest in the state of Texas, felony unlicensed carrying of a weapon in a prohibited place. Unless pretrial has something different, I don't have a disposition at this time.
That case was dismissed. His last conviction of any sort was over like 12 years ago.
All right, on count 3, I will ROR him, standard pretrial, phone in 3 times a week. He's to have no contact and no return to the areas alleged in counts 1 and 2.
Thank you, Judge. Let me give him a map. By what time does he have to report tomorrow morning, Judge?
What time you guys open?
At 8, Your Honor.
He should be there at 7:30 because they open at 8.
And Your Honor, does the court's order also include no contact with the listed victim?
Yeah, no
Okay.
contact, no return.
Thank you.
Yeah. Marquise Dudley?
Judge, I've been advised he bonded.
All righty.
Mr. Brennerless? Mr. Brennerless, you're gonna be next.
Samuel Brennelis?
He's here present, me.
All right, this is a hold on a warrant out of state. $50,000, cash only.
Thank you.
Thanks. Cornelius Jackson.
Mr. Jackson's here present, Judge?
you. All right, Mr. Jackson, bond set, count 1 at 1,000, count 2, 7,500. There's a misdemeanor capias for 3, that's set at $250.
Judge, if I may, in reference to Mr. Jackson's case, in reviewing the probable cause affidavit, I don't think there's probable cause here. He's the passenger in a vehicle. The firearm is not accessible from the front seat, but it's concealed under a book and several bottles of water. The only evidence presented in this probable cause affidavit is that Mr. Jackson was in a car. There's no indication he had knowledge of this weapon, had any possession of this weapon, ever touched this weapon, or even knew that the weapon was there. It was hidden and concealed.
Your Honor, if we were at trial, I could understand, but this is for a probable cause determination based on the circumstances laid out in the probable cause affidavit. I think the officer had probable cause to make the arrest.
I think if someone had come into court before Mr. Lender arrived and taped a package of cocaine underneath his chair when he sat down, and he didn't know it was there, then he would probably be making the same argument as to why he should be held in custody, because he didn't know it was there, but he was close enough to it.
Oh, underneath my table is accessible to multiple people.
Even more reason that there's no probable cause.
Well, in this case, it indicated that the only person that it was readily accessible to was the defendant, so.
And it's also indicated that it is concealed and hidden under books and bottles of water and not clearly visible to whoever might have just happened to be sitting in that seat. And if Mr. Jackson is guilty of anything in this probable cause affidavit, it's of being in that car.
I do find probable cause, although I think your argument is well taken when whoever looks at this case and beyond it to the exclusion of a reasonable doubt standard, I think the state might have problems there.
Judge, and
I'd like to try it.
If I could be heard as to bond, and speaking with Mr. Jackson, he's 18 years old. He's been residing here his whole year. He is going to high school. This fall, he starts his senior year at Hallandale High School. He is playing sports. He plays on the basketball team. At this time, he's not working. He lives with his father. Him and his father. He lives with his father's a single father, unfortunately. Mom's not there right now. His father works at a water plant doing manual labor. Judge, at this time, we'd be asking you to consider, considering Mr. Jackson's lack of financial resource, but his strong ties to community, we'd be asking you to consider standard pretrial on counts 1 and 2. I'd also ask you, I know the court has found probable cause, but you could look at for mitigation purposes the strength of or the weakness of the state's case. As my colleague stated, this is a constructive possession case. At the very least, we don't know how many individuals are in the car. There's at least 2 people, a driver and a person in the back seat. We don't know if there's a person in the front passenger seat that also was accessible to the firearm, which was located under the driver's seat. So there's a lot of speculation. So I'd ask you to consider the weakness of the state's case and ask you to consider pretrial release on behalf of Mr. Jackson.
And Your Honor, normally, if you'd like, I could provide you with Mr. Jackson's juvenile history. We usually do that sidebar. I believe those aggravating factors would, at a minimum, leave the court inclined to keep the bond at $7,500.
I'm comfortable where it's at, and considering that there's, on the face of this thing, there was a capias on a misdemeanor case, and these are much more serious charges. He's already a convicted felon at the age of 18, and it seems that.
And Your Honor, I apologize. Technically, what I believe what the officer said, he's an adjudicated delinquent. It's the same effect, just a different subsection of statute.
I got you.
Thank you.
Thank you. John Davis.
So reset.
Mr. Davis, I've been informed it's going to be a medical reset.
All righty. Charles Simpson.
Conti, Your Honor.
All right, and this is a change of charge. I will set bond on this at $7,500. Andre Hampton.
He's a medical reset.
Thank you. Nixon Ward.
Mr. Ward is here, present judge at Maine. I believe he's here on a change of charge case.
That is correct. I will set bond
Your
on
Honor, Your Honor, if I may, I just want to see what the original bond was set at, because it appears it was changed from one type of aggravated assault to another.
Went from a third to a second.
Yeah, I was going to be asking, actually, Your Honor, does the jail know what the bond was originally set at?
I think it was fine when I looked in the system, but I could be incorrect. But he's being held no bond.
He's got a no bond
I
hold
was
on
just
some
going to
other
be,
charges.
I was just going to be asking that the original bond be kept in place, Your Honor.
Well, I was going to set it at 7,005. You want 5?
He's got a no bond hold, I'm fine with 5. Your Honor.
7,500.
Well, whatever.
Todrick Holland.
Mr. Holland is approaching, Judge. Judge, Mr. Holland did inform me he has private counsel, Mr.
Who
Dean.
appears to be approaching right now.
Your attorney, fine attorney.
Good afternoon, Judge.
Good afternoon, Mr. Dean.
Judge, on Todrick Holland, we would be contesting probable cause on this case, in this case. Judge, if I may,
Yes, sir.
Mr. Holland is a co-defendant to a Mr. Riles. Mr. Riles committed a burglary where subsequently, allegedly, a murder was committed. My client's only tie to that is this case where my client has consistently maintained that he didn't know anything about the murder case. He hasn't been charged with it. There isn't any evidence that he had anything to do with it. Subsequently from jail, according to the affidavit that's before me, Mr. Riles called a Mr. Newsom, and he three-wayed a call to Mr. Holland, my client. My client got on the phone. They discussed whether or not my client was willing to come into court and say that the state was offering him or tried to get him to say something about a case that he didn't know anything about. So that's the total substance of the probable cause, reasons for the charges, Judge. The two charges that my client is charged with is unlawful use of a two-way communication because allegedly they discussed a felony act over the phone and conspiracy to commit perjury. There cannot be perjury, Judge, if he's telling the truth. He's maintained consistently that he doesn't know anything about the second case. There isn't probable cause in this case.
State?
Yes, Your Honor. First of all, as Your Honor is already aware, probable cause was already found in this case by Judge Siegel per the arrest warrant that was signed last weekend. But furthermore, Your Honor, wiretap call 179 is where these acts were committed. And there was a conspiracy to commit perjury, not only as to the murder, Your Honor, but also to the burglary, where Mr. Rosiles and Mr. Holland are charged co-defendants. And that can be heard if you listen to the actual call, which I'm pretty sure Mr. Dean has not. So, Your Honor, I would submit to you that there is probable cause as indicated in the affidavit, and I do have an extra copy if Your Honor would like to see it, but. Okay.
Judge, I read call 179 that she supplied to me, and I thank her for that, but there's no mention of any evidence that Mr. Holland knew anything whatsoever about the murder. That's not even alleged in that affidavit. The only thing is the calls. That's it.
Well, I'm going to agree with or affirm the findings of Judge Siegel on the arrest warrant, find probable cause, bond set, 10,000 count 1, 20,000 count 2, plus level 1 with GPS, surrender passports, and
Judge, would you be willing to waive the passport
No firearms.
requirement? My client does not have a passport, and he can't meet that requirement.
well, he can't surrender what he doesn't have. You can file an affidavit with the court saying that he has no passport to surrender and never has had one.
And Your Honor, as I mentioned before, Mr. Holland is currently charged with Mr. Rosiles in a pending burglary dwelling, and that's case number 145513, CF10A, and I'll be asking to revoke his bond on that case at this time.
Judge, we would be asking for a hearing on that, a formal hearing on that. And the reason why, Judge, is because just as I laid out, that's the only allegations in this, is that Mr. Riles called my client through someone else and asked him to testify that the state was trying to get him to testify about something he didn't know about. That's the complete essence of the charge.
Do you represent him on the other case?
Yes, I do.
Okay. Well, the court having probable cause to believe that while out on bond on case number,
145513 CF10A.
he's been picked up on new and serious felony criminal charges, I will revoke bond in the previous case, and he will be held without bond pending trial. Thank you, sir.
Thank you, Your Honor.
Your Honor, we had a case this morning, a Sharice Andrews. She was in transit at the time, so we were not able to get her called this
Yeah,
morning,
it
but
said
they do
reset.
have her now.
Okay, I've got it,
Okay,
but I need to look at it because
Okay.
it was just handed to me. Thank you.
all right.
All right, and where's she
I
at?
think she's in North Broward.
Okay, there we go. All right, I do find probable cause on 1, 2, and 3. Bond is set at 1,000 on each count, and count 4 is a violation of probation. It's no bond. All right, now we have this other docket thing. They're all motions for ROR?
All the misdemeanors except for one are second looks. The felonies, I believe, are motions for release, Judge.
All right,
Judge, I know we're on the second look docket. I don't know if you called this gentleman, he's the last person here at Maine. His name is, Mr. Brian Johnson.
I don't have anything on that.
Sheila, did you get the?
He should be on the, second look docket, Judge. Along there's, I see 4 other people on the second look docket.
Okay,
Your Honor, while the PC is being passed up, I can tell you that Judge Cantor increased the bond yesterday morning to $1,500 based on the specific allegations in the report.
We can't hear anything.
Do you want to repeat that, Mr. Lender? They couldn't hear you.
How do they know I was saying anything? I advised the judge that Judge Cantor raised the bond to $1,500 yesterday based on the allegations in the PC affidavit.
Correct, Judge. It is a misdemeanor offense. It was originally $100. The judge raised it to $1,500. At this time, he's here on the second look docket. What we're asking you to consider at this point is potentially to ROR Mr. Johnson. In reviewing, I know the PC affidavit, there's more to the story than meets the eye. And he'll have his opportunity in day in court. I know he was assaulted and he was getting treated, and when he woke up, he didn't know what was happening, but that will be sorted at trial. Judge, what we have before you is a misdemeanor offense. He's graduated from Johnson in Wales. Unfortunately, him and his wife got divorced. He's going through some hard times. He was working as a cook in a food truck, and now he's unemployed. He's looking for work. Judge, he's 35 years old. He doesn't have the money to post bond. We're asking if you would consider an ROR.
priors, if any?
Your Honor, the only thing I saw was a 2011 theft. That being said, I do believe, based on even if it is a misdemeanor, based on the specific allegations in this case, that if, and Judge Kenner obviously took into consideration his financial abilities, I do think the bond that was set is appropriate.
Judge, I know on his face assault on I believe it's
EMT.
paramedic. It looks bad. However, I mean, it's plausible. I can certainly see if a person experienced some sort of traumatic event, was beat up at a beach, they're transporting, he's laid out, and then he wakes up and he doesn't know what's going on. I could see where it's possible to have some sort of reaction like this. Once a person gains consciousness, realizes what's going on, of course, then that would have been inappropriate behavior. But we don't know the circumstances. At the very least, it is only a misdemeanor. That's why I'm asking you to consider an ROR.
And Your Honor, and I don't really want to say certain things in the report that the court's aware of, but certain things that I don't think really jive well with that claim. Making some of the statements he made, someone could come at a trauma, making a racial epithet. I don't see how
We
that's.
can find free speech to be distasteful, but that shouldn't be the basis of whether or not the person's a flight risk. Did pretrial services have a chance to
No,
interview?
Your Honor, not on this charge, typically look on this charge. It came in as a misdemeanor. Only reason the bond is this a month because the judge paid.
And Your Honor, I wasn't, and just to be clear, I wasn't trying to claim that alone. I'm saying combining that with the allegations of what he immediately did right after that.
You make any kind of monetary bond?
No. Right now, like I said, he's divorced. His wife is helping him out by allowing him to stay at her place, but that's about it. That's the extent of their relative good terms. And like I say, he's unemployed, he's looking for work. He was working on food trucks.
Support or alimony.
All right, I'll do ROR, standard pretrial, phone in 3 times a week.
Thank you, Judge.
Your Honor,
All right,
you could just tell
you
us
have
for
to
the
go.
record where he's going to reside.
Sir?
Hold on, Mr. Johnson.
On the record.
Pretrial release wants to know your address.
It's 3108 Merrick Terrace in Margate, Florida,
What did he say, Merrick?
33063.
Can you spell Merrick for us?
Merrick.
Okay, thank you.
So the address.
Thank you.
located
All right,
for
you
South
have to go there
Carolina is-
in the morning.
Pardon?
So you have to report.
Hold
to
on,
the proper-
hold on.
Hold on.
Looks like he had a South Carolina address. That's what we were.
He did.
If the court's inclined, you don't want us to verify him, just send him out regular, because the address he gave us.
Verify it.
Okay, so he's
Yeah.
pending verification then.
The address will need to be verified because he is saying it's his sister's or whatever, and I guess she has
It's my
to,
wife's. It's on my Florida driver's license.
well, it's gonna have to be verified that he can actually stay there.
Thank you, Your Honor. So he's pending
Thanks.
verification.
How am I gonna do that? Nobody's there.
You don't do that. They do that. And if they can't, then
But
you
nobody's
stay in
there.
or you post the monetary as an alternative bond. Thank you.
I'm the only person that lives there.
Is there any alternative as far as,
I'm not just gonna release him without any kind of verification. So he can either do the monetary, or if it can be verified that he has an address where he can stay at, can be monitored.
Tell them they stay. She stays.
hold on. You have her phone number, right?
It's a.
You have a number, even though
It's
she's
a
involved.
Bahamas number.
Okay, give that to pretrial.
But
They have to try and contact and verify.
Okay.
All right, they're not just gonna sit there and just do nothing. All right, thank you, Judge.
Thanks. All right, now we have these ROR motions. Alicia Castaneda.
Wanna wait for appearance. You're up.
She's at Paul Ryan. I'll get her right now, Judge.
All righty. Certainly nicer than the old courtroom. Yeah, except for the, should have the clerk right here.
If you want to call, I believe the gentleman sitting there has a motion to release also at Paul Ryan.
Who is it?
I believe that's Ronald Spradlin.
Ronald Spradlin?
Would waive formal mentioning of the charges.
The state has not yet filed an information. Mr. Spradlin is entitled to an ROR. Your Honor, we would ask if you could just advise Mr. Spradlin that the original no contact order is still in place, though.
Did you hear him?
Yes, sir.
All right, so because the state has not filed an information within time, you are entitled by law to ROR, so I am doing ROR. However, you should understand that the court's no contact order remains in effect. Obviously, violating that will find you back where you are now.
Yes, sir, Your Honor.
All right, and as I tell most folks who get released without charges having been filed, it's important that the clerk's office know how to get a hold of you. Because again, if charges do get filed and it's set for an arraignment and they have the wrong address or something, you're not gonna get it, and then miss court and no bond and all that kind of stuff. So you wanna make sure that they have the correct address.
Yes, sir, Your Honor.
All right.
Thank you, Your Honor.
Yes, sir. Charles Hawkins.
Your Honor, the state has not yet filed an information. Mr. Hawkins is entitled to ROR on these charges.
Very well. ROR, Mr. Hawkins. And again, state has not filed its charges in the case. They may or they may not. So you're being released ROR, but that means there is no future court date at this point. So you want to make sure that whatever address that they've got at the clerk's office is a good one, because otherwise you'll get notice for an arraignment. If it goes to the wrong place, then a warrant's issued, you're back where you are now. We all want to avoid that. So just make sure people know how to get a hold of you.
Yes, sir.
All right, well, I guess you're still being held on a VOP, so I guess we know where you're at for a while.
Yes, sir.
All right. Actually, do you guys want him ROR'd on a case if he's being held no bond and then he's technically at liberty? Okay, I'm just asking because, you know, two for the price of one. All right. All right, back on Castaneda.
Yes.
Yes.
Your Honor, the state has not filed an information at this time. Ms. Castaneda is entitled to an ROR on this charge.
All right, you're going to be ROR on this count. As I've told the other folks, I don't know if you guys can hear all that. Because you don't have a future date and they may end up filing charges, make sure that there's some good address at which the clerk's office has. Otherwise, your arraignment notice will get sent somewhere. And if you don't know, then there'll be a warrant. You'll back right where you are now. You want to avoid that. So make sure they know how to get a hold of you if they file an information, or if they decline, you want to know that as well.
Yes, sir.
All right, good luck.
Thank you.
Dino Tiberio?
Your Honor, again, the state has not filed an information at this time, so he's entitled to an RRR on his charges, which just asks that he be advised that the no contact order issued in this case is still in place.
All right, sir. They have not filed charges in your case. You're entitled by law to be released on your own recognizance, so I will ROR on counts 1 and 2. You should be advised, however, that the no contact order remains in effect, and you should make sure that the clerk's office has a good address for you. If the state at some point decides to file an information, you want to make sure you're notified of the arraignment and don't miss a court date. All right?
And, Your Honor, it appears he has an out-of-county hold also.
And you may be, appears there's an out-of-county hold, so you'll probably be here until they pick you up. All right, good luck. Then we got Terry Washington.
Conti, Your Honor.
Your Honor, the state has not yet filed an information on these charges. Mr. Washington is entitled to release at this time on these charges.
All right, your ROR on these counts 1 through 4.
Yes, sir.
And as I told everyone else, make sure that the clerk's office has a good address for you because there is no future court date. If the state does file charges, you want to make sure you get notice of that arraignment so you don't miss your court date and then end up with a warrant and right back where you started, all right?
Yes, sir.
Good luck. And then there was an add-on here.
There's 3 misdemeanor cases.
Pardon?
We have 3 misdemeanor
Well,
cases.
there's an ROR motion add-on for Dean
Yeah,
Deckley.
yes.
Well, is it a non-filing?
Yeah, it's not filed. I was gonna obviously ask the court to advise him that there's no victim contact, but can't do that, so, but
Right.
he's entitled to an ROR.
Yeah. Whether he's here or not, I'll do the ROR.
We'll waive his presence for purposes of him being released on his own recognizance, Judge.
All righty, so ROR. Why don't we put on this order that the no contact remains in effect? Okay,
Thank you, Judge.
it's at least on the written order. Okay, what else we got?
There's 2 other misdemeanors, Bradley Wunderlich and Richard Barraclaw.
Bradley Wunderlich, he was here at Maine, Judge, and my understanding is he decided not to join us today. He declined.
I didn't even know it was RSVP, but, okay.
Is that what we can do?
He's on his second look docket on a trespass.
It's a shame he didn't join us, but maybe he just wants the meals, I don't know. All right, what else we got?
Richard Barraclaw, that's a municipal.
All right, have a great day.
Thank you. Conti, Your Honor. Conti.
He refused to come.
All right, so he's gonna go send to division.
Yeah.
This is Mr. Barraclaw, Your Honor. He's in custody on a municipal ordinance offense.
Okay, and is there anyone here from that municipality?
Not that I see.
And what is the charge? If you,
One moment, Judge. Appears to be trespassing on private property or trespass.
how long you been in, sir?
This was an ad charge. He's been in custody since the
22 days?
He's been in custody since the 21st of June. The case was issued on the 29th. So he was in custody when the case was issued. And actually,
Capias is on like 5 other cases, so.
All right, so we can resolve this?
I don't have a say.
know you don't-
But by all means, yeah, sure.
You want to resolve this case, sir?
Yes, sir, I do.
All right, what are you pleading? No contest?
Yes.
All right,
Yes.
time served.
Thank you, sir.
All right, is that everything?
Hope so.
All right, wonderful.